let's get into sentencing and punishment. All right. As I said, I'm focusing on areas of the syllabus that people, it's not their best compared to the first half of the syllabus. I'm not sure if it's because the first half of the syllabus we're still eager to learn and we're ready, and then by the second half, legal studies starts to drown us in content and we start to kind of, I don't want to do this anymore. I'm not sure, but nonetheless, let's go through it. So, sentencing and punishment. You need to know the main act for sentencing and punishment is Crime Sentencing and Procedure Act 1999, New South Wales. That is your holy grail, okay? That is where we have the statutory and judicial guidelines for sentencing. We have all different, we have the purposes for punishment. We have mandatory sentences. We have everything under that act, okay? It's the main act you must know for sentencing and punishment. All right. Let's go through statutory and judicial guidelines. What are judicial guidelines? Well, they're guidelines which basically, I don't want to say guide, but assist judges in sentencing decisions, okay? It comes from seminal or really important judges from the New South Wales Court of Criminal Appeal, okay? And yeah, it's decisions in sentencing which help other judges with similar cases come up with a sentence. So let's say I have someone who, I don't know, assaulted another person and I'm a judge and I'm unsure of the sentence to give them. I can refer to other cases where similar things have happened, where there are assault cases that were similar and the sentences that they got. Okay, and I can basically base my decision off those similar sentences and use that to inform, all right, I'm going to give this person the same sentence that those judges gave them. This helps with consistency. And yeah, the main thing is it helps with consistency. So people can't be like, I assaulted someone and I got 12 years. They assaulted someone and they got 3 months. That's not fair. So it helps it be fair and consistent. All right, so judges read cases and pick the best examples of sentencing decisions, which therefore form judicial guidelines for the judge. The aim is consistency. As I said, the process needs to be predictable. You need to be able to say, all right, I assaulted someone, I'm going to get this amount of time. Okay, it's not just like, 3 months, 3 years, 12 years. It can't just be random and arbitrary. There are 8 judicial guidelines. For example, when someone pleads guilty to armed robbery, judges may wish to follow the guidelines from R v. Henry 1999. Okay? However, the big thing here is that it's a judicial guideline. It's not a judicial rule or they must follow it. Me as a judge, let's say I'm a judge, I can choose to base my sentencing decision off those similar cases. I don't have to. So I have what's called discretion. Just in case we're not aware of what discretion is choice, okay? I have the discretion, I have the choice to base my sentencing decision off those cases, or really I could say 13 years. Even though it's usually 3 months, I'm going to give you 13 years. Now that might be appealed and they might fight that sentence, but that's not the point I'm trying to make here. The point I'm trying to make is I have discretion as a judge, even though there are judicial guidelines. However, in saying that, it's very rare that a judge is going to do something like that, okay? Because they want to create consistency. It's better for the whole legal system overall. Statutory guidelines are very similar, but they're acts, okay? They're pieces of legislation which basically delegate, for this crime, you want around this sentence. For this crime, someone should receive around this sentence. It's the same sort of thing. It's a guideline, right? There are a number of acts of parliament. That they may wish or have to follow. We'll get into that in a second. So the Crime Sentencing Procedure Act 1999, New South Wales, is the primary source of sentencing law. And within that act, you have statutory guidelines. Standard non-parole periods for some crimes were introduced within that act that was amended in 2003. So just in case we don't know what a standard non-parole period is, SNPP, it is the period of a person's sentence that they can't be released on parole. Parole is the conditional release of someone who was serving a prison sentence out into the community, of course, as I said, on those conditions. So if I'm in prison and I've been really good and I haven't started any fights or riots or anything, I can be released in parole, and my conditions are maybe that I can't leave the house, I need to check in with my correctional officer every week, and I have to wear an ankle monitor. Let's say those are my conditions. That's parole. A standard non-parole period then is a period of which of your sentence you can't leave, you can't get parole. Okay, and that's a part of statutory guidelines, because judges will look at that in your sentence and say, all right, 3 years, and you have a standard non-parole period of, let's see what the law says, 2 years. Yeah, that's fair, 2 years. Okay, that's what they do. Some crimes have a maximum and a standard non-parole period. So, for example, armed robbery has a 25 years max sentence that you can receive and a standard non-parole period of 7 years. So, speaking of which, police are going past my house right now. Armed robbery, for example, so statutory guidelines don't always have to be the minimum that you can receive for doing a certain crime. They can also be the maximum. So a judge can't give more than 25 years for armed robbery. All right, mandatory sentencing. This is very different, okay? Because the discretion that we had, remember the choice of the judges that we had in judicial guidelines and statutory guidelines has now been completely obliterated. We don't have that anymore as a judge. Imagine you're a judge, you have no discretion here. You must sentence what the Act says. So, Crimes Act 1900 New South Wales was a catalyst for change. The big mandatory sentence is for the death of a police officer, okay? If you kill a police officer, there's a mandatory sentence that you will get. As a judge, let's say I'm a judge, this person murdered a police officer, I can't say, I have no opinion over what sentence they'll get. They'll get the mandatory sentence, okay? Discretion has been removed. Now, the big issue with this, and why you would want to talk about this in an essay, hint, hint, I would pay attention, is because it doesn't take into account any aggravating or mitigating factors. And we know that they were designed to help keep justice, okay, or achieve justice. So, for example, if the person was let's say 18, killed the police officer, so they're very young, and then they're crying in court and they're talking about how they've gone through, deep mental issues because of this, and they're showing great remorse, they will receive the exact same sentence as someone who is happy about what they did, couldn't care less, and has no worries about it, okay? That's an injustice, because obviously there's two different offenders there. One person who seems as though they may not offend again, or is happy to get rehabilitated and stop offending, and the other person who, as I said, couldn't care less, right, wants to keep offending. They will receive the exact same sentence, which is an injustice. So when you're talking about sentencing punishment, mandatory sentencing, bing, 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 I would definitely talk about it, because there's a big injustice issue there. On the one hand, with something like the death of a police officer, we want to protect police officers. We want them to have their authority, because then, we have complete anarchy and everyone's just running amok. But on the other hand, we want justice for these offenders, which we don't get with mandatory sentencing. And in the media, high incidences of drunk, disorderly behavior and violent crimes fueled by alcohol in the community. So the one punch laws also have mandatory sentencing. So I don't know if you guys, I think you guys should remember the one punch laws when King's Cross in Sydney was like in its heyday. We used to have people, it's also called the coward punch, where people come up and punch other people from behind and they don't see it coming, and then we had some deaths from it. Hopefully we remember the death of Thomas Kelly as a key case in legal studies. If we don't, Thomas Kelly was killed by one punch. By Loveridge, okay? Arvis Loveridge. We need to remember that. Loveridge came up, punched him from behind. He died because of that. Because of the media outrage toward this and saying that Kelly shouldn't have, like, there should be a really harsh penalty on Loveridge, we introduced mandatory sentencing for anyone that does a one punch to someone and kills them. Okay, so mandatory sentencing there again. On one hand, it was satisfying the community because the community was really outraged and wanted tough penalties. On the other hand, for the offender, remember, we're balancing the rights of victims, offender, and society. For the offender, again, those aggravating, mitigating factors, we threw them out the window. All right, this is what I was talking about for the police officers. This is the act that you can reference if you're talking about this in an essay. You receive a life sentence. Sorry, I didn't say that earlier, but you will receive a life sentence if you murder a police officer. Again, there's no judicial discretion. The key case that we see this in is R versus Jacobs, 2013. Jacobs received a life sentence for the murder of a police officer. So in a paragraph, that's a key case you could look at. This, as I said, creates serious justice issues, right? It's an injustice for the offender. The key case that is still printed in my mind from when I studied legal studies is Sydney Morning Herald, 2011, is a policeman's life worth more? Okay, that's basically a media case where the journalist discusses the fact that, yes, we need police officers to have their authority, we need people to respect them, but on the other hand, is it more than any other person that gets murdered? Because if any other person on the street gets murdered who's not a police officer, who's to say that their offender, or the person who killed them, will get a life sentence? They won't. So there's another justice issue. We're not sure, the question, is a policeman's life worth more? Parliament is also, another thing you could talk about is Parliament is taking over the role of courts. Okay, this is another issue with mandatory sentencing. We remember, if we can, the separation of powers. We separate the Parliament and the judiciary, or the courts, okay? Meaning that the Parliament, in theory, shouldn't be able to have any say over the judiciary or the courts, okay? Vice versa. The judge shouldn't be able to come out and start doing what the Parliament should be doing. That is what we want, right? That creates a check and balance, meaning that if the Parliament's doing something wrong, the judge can come out and criticize it, and then vice versa. If the judge is doing something wrong, Parliament can come out and criticize it. Both can criticize each other. Okay, and the executive all can criticize each other, police force, judge, and Parliament. Now, if we have the Parliament saying to the judge, nope, you have no choice in this sentencing, I'm going to say that you have to give him the life sentence, you can see that's pretty much silencing the judge. It's pretty much the Parliament doing the role of the judiciary, right? So that separation of powers that we love and is good for justice is starting to be impeached. So that's another thing. Not only do we have the injustice of the offender who may or may not receive, as we're talking about aggravating, mitigating factors not being considered, we also have people outraged about similar crimes done to different people and not receiving as harsh a penalty, such as, is a policeman's life worth more? And then we also have the issue of the impeachment of the separation of powers. So there's a lot to talk about here. You could try and talk about them in one body paragraph. I, however, think it would be more suitable to only talk about one of those issues per body paragraph. Trying to talk about all of it together and trying to fit in all your evidence might be a bit too much. So maybe choose one or two of them to do together. Okay, and then, there's another piece of, there's a newspaper article that you could use where it talks about that judicial discretion being overtaken and the separation of powers being disrupted. Okay, this is for what I was talking about before. This is for one-punch laws, okay? The Crimes and Other Amendment, Assault and Intoxication Act. Arvis Loveridge, 2013, as I said, it was initially, there was a lot of outrage because he received 4 years for a life, or 4 years, it should say 4 years for a life. Sorry, I don't know why it says 4 years a life. He initially received 4 years. But there was outrage, and then it was increased to 7 years on appeal by the DPP. Okay, so now there's a mandatory minimum sentence of 8 years. Okay, again, as I said, there's no mitigating factors and no judicial discretion. All right, R versus Garth 2017 was the first case where we saw this law be implemented in an actual case. Okay, so Garth was convicted of under the one punch laws and received 8 years. Okay, with a standard non-parole period, 10 years with a standard non-parole period of 8 years, as per this legislation. Okay, so that's all about mandatory sentencing and statutory and judicial guidelines. I'm not going to sway your position on this, but here's something to think about. Statutory and judicial guidelines can be good because they give the judge an idea and help inform them on what might be a good decision for sentencing, but they also empower the judge to think about the mitigating and aggravating factors, okay? So there's that discretion there. There's also the protection of the separation of powers. There are statutory guidelines, Parliament saying, hey, this is something you could do, but we respect that you have the choice. However, as we just said, mandatory sentencing, that's abolished. Okay, now we're moving on to the purpose of punishment. These are all the different purposes of punishment. So to ensure that the offender is adequately punished for the offence, to prevent crime by deterring the offender and other persons from committing similar offences. Remember, that's specific deterrence and collective or communal deterrence. Or general deterrence also, to protect the community from the offender, to promote the rehabilitation of the offender, to make the offender accountable for his or her actions, to denounce the conduct of the offence, to recognise the harm done to the victim of the crime in the community. Now, judges will usually state or reference one of these, actually not one, multiple of these reasons in their sentencing. They will likely reference like, this is the justification for my sentence. This is why I've done this. This is really important if you have a case where the judge has considered mitigating factors, meaning the judge has lowered the sentence because the person has showed remorse, or because the person's young, or this is their first offense, or because the person's an elderly person. All those mitigating factors may reduce a sentence, and so it's important that we hear the justification of the judge that this is my actual purpose for punishment. No, it's not really to, ensure the offender is adequately punished. It's more so to promote the rehabilitation of the offender. All right, deterrence. As I said, 2 types of deterrence. Remember, as a solid definition of deterrence, it's to discourage people from committing the same crime. Best example I can give you is if you're sitting in your class, think you're in legal studies, just imagine sitting in class, you hear that you have a sub that day, you have a substitute teacher, your teacher's not coming in, you think, oh, sick, I'm gonna go on my phone, I'm gonna relax, I'm gonna watch some TikTok. You're going on your phone, you're waiting for the substitute teacher to arrive, you relax. Imagine I walk in as a substitute teacher and I'm really angry for some reason, and I see your friend on their phone and I scream at them, I say, get off your phone, you're going to get a detention. What are you going to do? Are you going to continue going on your phone and relax, or are you going to, okay, let me start doing my work. You're going to start doing your work, okay? That's deterrence. I've deterred you from not committing the crime, but misbehaving or going on your phone. I've made you start doing your work, okay? Specifically, that's general deterrence. I'm trying to scare everyone into not going on their phone. Just like when let's say I'm a judge, give someone a harsh penalty, I'm trying to make them not, or everyone else in the community not commit the same crime. Specific deterrence is punishing an individual in a way that would discourage them from doing it again. So the sentence is really tailored to them, and maybe that they can't see a particular person, or they can't leave their house, or some sort of condition in their sentence that makes them never want to commit the crime again. Okay, so there's 2 types of deterrence. Retribution is that the sentence should be morally right or deserved, appreciating the nature of the crime. So revenge. The big thing is revenge. An eye for an eye, you commit the crime, you should serve the time. We're going to breeze through these because I want to get back to the essay stuff, the beefy stuff you can talk about. Rehabilitation, hopefully we all know what rehabilitation is. If we don't, it's basically to reform or help the offender so that they stop committing the crime. Rehabilitation is really, you really have to look at the social factors that contribute to crime. Okay, so you need to understand, why is this offender committing crime? You can't just talk to them and say, hey, don't commit crime. You need to understand, maybe they're committing crime because they don't have an education and therefore they can't find work and therefore they need to, steal and rob and whatever. Maybe because they grew up around crime and it's what's normal to them. Maybe they have a disability and they don't understand. You need to understand the factors of crime to really rehabilitate someone. So in sentencing, that's what we're trying to do. We're trying to steer someone toward help, to help them tackle what's really motivating them to commit crime. So an example of that is the alcohol merit program for people who suffer from alcohol abuse, to try and rehabilitate them and, help them end that alcohol abuse so that they don't commit crime, because that can be a driver for crime, alcohol and drug abuse. Non-violent drug offenders must participate in rehabilitation in combination with probation rather than submitting to incarceration. So the drug court isn't for people who were trafficking drugs or were dealing drugs. It's for people who abuse drugs, okay? And their sentences are really not tailored to retribution and revenge, really towards rehabilitation. How can we get this person off these illicit substances and therefore help them stop the crime? It is effective because it's reduced recidivism, okay? Remember that word, recidivism. We don't want to say reoffending. We want to say recidivism, okay? It's reduced reoffending or recidivism by 37%, which is staggering. Incapacitation, this is literally arresting someone, okay? Keeping them incapacitated, not just in the form of imprisonment, but also not letting them do something like leave their house, not have their license, imprisonment, and be forced to do community work. Matthew Millat, we all know the Millat case, was given a minimum non-parole period of 30 years for murder of his friend with an axe. During sentences, the judge said that he remained a serious threat because he had no remorse and seemed to enjoy being known as a murderer. He had little motive for doing the killing. So it was a combination of retribution, but also we incapacitated Millat. Okay. Moving on to the role of the victim in sentencing. This is really important because now we're getting back to that beefy stuff. Remember, the judge doesn't sentence for the victim, but for the community. So we see a lot of the time in the paper, on the news, or on social media, the victim's family or the victim themselves standing in front of the court saying, an injustice was done today, my family, are hurt. That may be true, but the judge needs to focus on the community and what's best for the community as opposed to the victim. That's something that's always kind of misconceived, but remember, it's for the community. Victims of crimes do have rights under the New South Wales Charter of Victim Rights. Victims and their families prepare and present a victim impact statement, VIS. Okay, here's where your judgment comes into play, because what I'm about to say here really, I don't want to sway your opinion again, but there's some interesting things about victims' rights. So, victim impact statements. Let's look at those. They exist under the Crime Sentencing Procedure Act 1999, and they're heard during sentencing. Okay, they're not heard before sentencing. They're only heard if there's been a guilty verdict that the jury's decided, and all right, we're in sentencing now. The victim won't get up in front of the jury and start talking about, the emotional and physical distress that they've suffered at the hands of the offender or the victim's family. That won't happen. Only happens in sentencing. The victim impact statement outlines how they've been affected emotionally, financially, physically, mentally by the criminal activity that happened to them. The reason, it gives the victim an opportunity to be heard. Now, gives them an opportunity to be heard, but a lot of the time it doesn't really carry much weight because the The judge, again, doesn't sentence for the victim, but for the community. So in the face of the victim impact statement, hearing it, seeing it, whatever, the judge can still decide to go forward with a sentence that's not in the interest of the victim. Okay? So it almost sometimes it feels like the court is just saying to the victim, yeah, have your say, come on. All right, done. All right, anyways, that's sometimes what it can feel like, especially when the judge is focused on rehabilitation, because obviously that's going to upset the victim and the victim's family. Now, victim impact statements must be disclosed to defense prior to being tendered in court, as there is an opportunity for it to be cross-examined. In 2008, the law allowed for certain victims to give victim impact statements via CCTV, and recently on Zoom, obviously because COVID and just the convenience with that. Liam Knight gave a victim impact statement after injuries from head injuries. Catherine Smith gave a victim impact statement in regard to the effect of 30 years of domestic violence. Now, why am I telling you this? Because if you're writing an essay about the role of the victim in sentencing, those are two great examples that you could talk about. If you want to talk about how it's good because it provides victims with a voice and allows them to feel like they're heard and it empowers them, I would be jotting down these names straight away. Okay? Prior to 2014, only the primary victim could give a victim impact statement. This is true. However, now family members who are also affected can give a victim impact statement. Family of homicide victims could read out a victim impact statement, but couldn't be taken into consideration during sentencing. However, now they can. But the question is it? Do we always see that? It was a catalyst for change, as the Kelly family were devastated when the judge couldn't take into account the victim impact statement, while Loveridge used character references to reduce his sentence. Okay, that reform that happened was as a result of the Kelly case. Okay, so we can now consider, under this piece of legislation, a family victim impact statement in homicide cases, which obviously is really important because the main victim in that crime is deceased. So only the family stand to, kind of voice their pain. Was used in all these cases here. Robert Z is a really seminal, important case to remember. I would also be jotting these down. Victim groups such as Vocal welcome the new laws as they can lead to an increased sentence, sometimes, allows the victim's family to be involved in the justice system by letting the court know how the crime has affected them. However, there is no universal acceptance of reform, okay? As I said, it can be considered and it can increase the sentence, which, will be great for the victim, but it can also not, okay? And more often than not, it's not considered. And we see all the time in the news, right? We see the families standing in front of the court unhappy about what happened.